Hi. Another day in Wonderland, right? That's not what I think. Um, I'm going to do a short one, but first I want to explain something else. We're trying to make a decision as we begin what I'm calling a workshop, and some of us are calling it class, and I'll win. But basically, what we're going to do is take the best one we have, which started in state court and blew up magnificently. Something that I've said for a long time. And in fact, as I started saying it between 2012 and maybe 15, I decided that the problem was that everyone was taking on a burden that wasn't theirs, um, and especially the borrower. You know, and the burden means like, what do you have to prove? Okay, well, you were sitting in your house and somebody um, supposedly posted they were going to foreclose on you, and you may not have even known it. In fact, I'm finding that's happening more all the time. There's a lot of this. We didn't know anything, and that's not how things are done. That's not how things are supposed to be done. So let's talk about the foreclosing party, the plaintiff in a judicial foreclosure, and the defendant to your plaintiff in a non-judicial foreclosure. But remember, you're not really the plaintiff. You're analogous to the defendant in the wrongful foreclosure, and that's what you're suing for. But you have to sue them, and I don't know how much of that was designed to be this way or not. Um, it certainly was redesigned along the way. Um, so basically, um, and this is like I read one long case, and when it was done, they had straightened out something that attorneys were taking advantage of and using it the wrong way. I'm finding that is all the time now, constantly. So you need to remember that you're not supposed to, you don't have to, you're not expected to. In fact, it's wrong for you to do to prove that you're being you have a wrongful foreclosure, so you have a fraudulent action happening to you, and you think you have to prove it to the judge. And the reason you think that is because he's not paying attention to anything. He's not saying, "Well, somebody tell me why anyone can foreclose on these people." That is really the question. And remember, that's because you have to have standing, and then that's really where I'm going to go now is to standing in a minute, because I'm saying that this standing is a threshold issue. And if you just sit there and say nothing but, I am not in default with any of these guys, that's all you have to say. In fact, is if you say any more than that, um, you're testifying for them. The notes are missing. All the promissory notes are missing. We could play that game like, where do I think they went? And there's three places. All of them are probably true. Um, and how did we get to that? I think we're not against really smart people. We're against a whole lot of money that buys, your way through something. So let's just follow this. Standing is a threshold issue, and you could write a lawsuit, and we all thought that's what you did. You write a lawsuit, you take it in, and you give it to the clerk, and now there's a case, and that's not right. That isn't. Nothing's true about that. The most common law in all of the United States is contract law, which is what a promissory note is. It's a contract. And so following contract law is almost every case, except for criminal and family, it's everything. So the founding fathers did not want a litigious society, everybody suing each other all the time. And I didn't tell you what I was going to, is that what I'm looking at right now, just as we're ready to say, hey, here's what we're going to do. And this is what we're going to teach, and here's how we're going to do it in a quicker period of time, because almost no one's got a lot of time. Um, and it's never too late, but it can feel too late, if you get to an eviction and you can still get your house back, you know, that's very true. I've done that. I've won that when people were out of the house when they came to me. Um, but but um, what I'm thinking right now is that I'm seeing nothing is true at the beginning of the state case. And when I say the state case, you have the circuit court, or sometimes they're called a district court. That I think of district courts being federal, because they are. But basically, if somebody has done a non-judicial foreclosure, you know who it was. We don't know anymore. Now you got a successor trustee, and I don't think I want to explain that right now. If you don't know it, I wanted to stay with the other part. If you don't know who foreclosed on you and you find out a deputy sheriff gave the deed to your house to Fannie Mae because no one bid on it, this happened in one of my very last cases here. Um, I I mean, it's so implausible. I'm starting to think that in many cases, we may skip state court. The state court judges are definitely either dumber or crookeder, and really, they should be in jail for either one or for both or whatever. I don't care. If somebody lost their house because a judge didn't know what he was doing. Well, remember, state judges are um, elected like prom queens, just like homecoming. And so they don't have to know anything, and they think they do. That makes them incredibly dangerous. And if in fact they've started hiding everything, then let's just go to the court where hiding is not allowed, and that is to the federal district court in your area, and that's where cases start in federal court. Two reasons for that. You don't want to get beat in a state court and then try to go to federal, because if they adjudicated, if your if your state court case came to a conclusion, then you can no longer go to federal court. You have to go to state appellate court, and then state Supreme Court, and then you can get back into the federal system. But we're talking about years, and I have done too many long ones, my own. I think that if we can't tell, if there's not an action going on and there's not a party that's just absolutely, saying we have been injured and here's our concrete and particularized, remember, that's the proof it takes, concrete and particularized evidence, or they can't take it, they can't even go into your eviction court, unlawful detain or whatever it's called. You can't even get into it because that's a case. And if you haven't proven you have standing, and that is that you have said, we have suffered an injury. And here is our proof right now. Standing must exist at the beginning, or it can never exist at all. And standing, once found to be deficient, cannot be repaired. That's how they wanted it. They didn't want a whole bunch of trials going on like we have today. How did that happen? Well, 249 years, 250 years. I think the system just slowly bent from attorneys, not having to do continuing ahead, and so somebody does something wrong. And I think at first it didn't matter stuff. And then later it became an opportunity stuff. And then it became real opportunity to get a boat. And when I say get a boat, I mean, somebody wanted some money and they needed boat money. So it's a metaphor. Look it up. Look up a metaphor. Not right now. Okay. So if in fact I can see no use in sorting through your characters, because none of them are going to say they've suffered an injury. all they're ever going to say, and if any of you have gone very far into, a case, uh, you know that what the attorneys for the foreclosing party, who were not sure who they're even talking about anymore, and most of the time lately, they don't exist. And they'll say, well, Danny Hammond one time signed a promissory note. And on that same time, same day, he signed a deed of trust or a mortgage. And things went along just fine and went along and went along and went along. And then uh, Danny became unable to make his payments and started falling behind and got into default. And he cannot cure the default or has not cured the default. Therefore, we have the right to foreclose. They never say anything but we. And this is specific. Everything about it is specific. You can't pay the wrong person, and the wrong person can't make you pay them. It's against the law for either of you to do that. And if the judge gives your house away, which I've seen more than not, to a stranger to the contract, a stranger to the note, and they become a stranger, if we've got assignments of the um, security instrument, which is the mortgage or the deed of trust, if we've got assignments and nobody's saying that they're, you know, um, it, okay, what we have to do is, if that's what's going on, at the very beginning of every case, I have always said on my own, and I have everybody doing it now, the first thing you say is, the first thing you write down is your name, and right back behind that, you say, and I am challenging the standing of whoever the hell it is that is a foreclosing party and the subject matter jurisdiction of the court, because no one has tried to meet the constitutional, irreducible minimum requirements of standing. And that is to say you have an injury, prove you have an injury, and then prove that the causation of your injury is the borrower. They have to do that. I've never, ever seen it done. I've never seen it done. I've seen, you people rule for the for the fake uh, uh, owner of your debt, but I've never seen them write why they own the debt, how they got the debt, and what in the world made them assign a mortgage just because they lost the note. This should have been impossible for them to do. They should have figured it out before they got here. And for 25 years now, that's how long this has been going on. For 25 years, no one stopped them. So don't think they're smart. They haven't had to be smart. They don't know how they, if, my new theory is fast, fast, fast. Run over them, go as fast as you can. They can't adapt because they're not used to it. It hurts their eyes. It hurts their eyes. I mean it. Okay. So what do we mean by the constitutional, irreducible minimum requirement for standing? If your foreclosing party does not prove that they've met that requirement, there is no case. It's over. It's already over. And the judge must dismiss the case if no one has met the requirements, and the requirements were what I just said. They have to say those things, because only those things that makes them prove how they got your debt and why you owe them. Um, you can't just say that, Danny Hammond got behind on his loan. Yeah, fine. And we have the right to foreclose. Why do you have the right to foreclose? I don't even know who you are. Most of you don't know the characters. Almost everybody right now seems to know New Res. And New Res really is specialized loan servicing. No. Yeah. SLS, next name. They change it from SLS to New Res. Why did they do that? Could it be because they've been sued so many times that the world was getting onto them? Of course, that's what it is. They changed the names. So it doesn't say they'll have to change new res because they're doing that's almost every case I see right now. New res. Okay, that's not the end of it. It's new res LLC, and then it's new res LLC DBA, new res doing business as Shell Point. And somebody watching this video this evening or tomorrow, or if 12 of you watch it in the next week, 4 of you will say new res. Okay, so it's new res doing business at Shell Point, and they're saying, that they're um, they're collecting the debt and handing it, and taking it to the bank and putting the money in. That's all a servicer does. That is what they do. And the trustee thing, U.S. Bank Trust National Association, which that name doesn't exist. There's only 2 names. The U.S. Bancorp, which is the holding company that owns all of the U.S. banks that we see on the streets, and then U.S. Bank National Association. All of those banks we see on the street belong to it. But the name U.S. Bank Trust National Association, and how would you guys know that? I mean, it's glaring to me, but it took 15 years. I'm not smart. It takes a long time for me to learn something. Okay, so if U.S. Bank isn't a real person, or there's not a person from that company that comes to court and says, I have an injury, they write it, but they've got to show up. An attorney can't be U.S. Bank. There has to be a U.S. Bank there, and the attorney then represents them. But the attorneys we're seeing are acting like they are them. They're not saying it. Everybody believes an attorney can do that. They can't. So there's several things that can't be done that are. You can't assign the mortgage or the deed of trust. It just can't be done. You know, just believe that for now, because I've said it, and it's in on my website in words. It has to do with Cartner versus Longan. Just remember that. And the answer is the promissory note is essential. It represents the debt, and the mortgage. This is 1872, so they didn't have non-judicial foreclosures. So they said mortgage. The mortgage is incidental. It's not. It's not the deal. The deal is the note. And so the mortgage has to go wherever the note goes. So for the mortgage to even move, the note has to be sold or whatever, transferred in some way. Put into a mortgage-backed security, which there's something that nobody really knows about. So that's why I wanted to say that when I'm talking about the constitutional irreducible minimum requirements standing, and when I'm talking about the foreclosing party has to say we have suffered an injury, and here's our concrete and particularized proof, and it also proves that it can fairly trace the causation of the injury to the borrower. That's the same thing as the constitutional irreducible minimum requirement standing. That's what they do have to write, and it has to show up. And all you got to say is, I am not and have never been in default with these guys, and you won't be lying. Even if you don't know, it doesn't matter. It's the truth, because they didn't. It was their problem, not yours. Not for you to prove they're being, they're being doing a fraudulent act against you. The word fraud, what's that mean? It means they're hiding it. Okay, so how would you find it? How could you put that blame on you? There's no way. They have to prove it's an actual fact. There's an elephant standing right over there. Okay, can you know if I'm telling the truth? You'd have to come over here to my house, and you're all welcome, all 4 of you, and you'd have to see the elephant and touch the elephant. That's proof. That's concrete, and that is particularized. So to meet the requirements of standing, before you even have a case, And that's what I did that caused this judge to lose his mind. He was depending on Missouri's what seemed like an unlawful detainer was the worst. You couldn't argue possession. You couldn't argue the rightful owner. You couldn't argue anything about title. Well, maybe that was written right, because you also can't get into that court until you prove that these guys owe you some money and you're the lender or the foreclosing party. And so that's all the same thing. That's the beginning. The case cannot begin. So when you, at the very beginning, you say we're challenging standing subject matter jurisdiction, the court has to stop right then. That's been the law for 250 years, 249 years. And that's not what's happening. So I forced it to happen. And I mean, the judge got the sheriff, and they did some horrible things to older people with diabetes, need medicine. A young woman, 34-year-old woman, who had her baby's ashes in an urn, they wouldn't let, they evicted him. And no 10 days, no following any rules. The judge lost his mind. I think, I don't know why he hasn't quit. I don't know why he doesn't go to the client, my client, and say, what do you want? How much do you want? Because I think he's in a lot more trouble for going crazy than he was for just ruling for the wrong party. And for actually, he conducted an unlawful detainer, yet he did not have a party withstanding that had a right to be in there. So he, as a judge, you can't move a case forward without someone having standing. It can't be done. So if someone did it, they weren't a judge. So the judge that lost his mind, I don't know if he knows yet, he was not a judge. We made it really clear. I wrote it, so I guess I made it, but it's really was their case. But we made it really clear that he was going to do something stupid, and that here's what we're going to do when you do it. He did something stupid, and we did it, and it surprised the living. I I've never seen anybody do something so stupid to commit like 10 crimes on top of one and bring in the sheriff, who makes, what, $16 an hour, and a deputy sheriff making 14, $12 an hour. The damages here could be millions. I mean, they can't pay that. But the judge, he might have a house about the right size. We'll probably go over and look at it. And I've always said that I've said that since 2010. I think we should just, win this thing and go take his house. And now I may be there. So anyway, I'm done for now. What we're doing now is I'm trying to decide how often, or what is the situation we're doing to state court, suing in state court, especially if they've already done the non-judicial foreclosure. It's time to go to federal court. And I've got some secret lawyers whose names can never be divulged, looking at what I've written now. And we're going to know, we'll still know this week what we're going to do, what the workshop's going to do. We already know the case. We already know how we're going to try to set it up. And I should give you that detail pretty quick, but I think it's pretty important to know that the cost will be less if we skip the state court. And once they've made the error, once they're threatening eviction, then it's over. I mean, we've done all we can there. Maybe we do, just file a case just to block while we go on to federal court, but I don't think so. Again, I'm not that smart. I I didn't just know all this, but I can tell you that right now is the first time in 10 or 12, 14 years that I can say I know what's happening, and it happens just like I know it. the only thing about the judge, I knew that we were going to make him uncomfortable. That was the plan, is to make him just as uncomfortable as the defendants, the borrowers. Um, I didn't know that I would cause him to lose his mind, and I'd be sorry about that if I didn't think he was a dirty, rotten crook who's done it many times before. He did this as if I've done this all the time, and you pipsqueaks aren't going to stop me. He stopped. Is he beaten? No, not yet. Is he going to be beaten? I don't see how he gets out of it. It's I just finally got to that point. Um, I wish it made me happier, but it took too long. But it does make me comfortable to know that a lot more people are going to win now. And I believe that. And as what we do, everyone will watch. And when it works, then you'll see some lawyers jump in and then some more. And then you'll just see nobody doing the wrong thing. They'll do it like it's written. Okay. Um, I'm going to do that thing because I still don't have a producer that's here yet. So I'm going to try to do this. I'm going to say, hey, goodbye. I'm sitting back, but my producer is going to turn us off over in the booth, you know, the booth at the diner. Okay. See you guys later. And I'm trying to hurry. I want to get this over with as much as you do, but I want to do the right thing. And it's hard to do in the world today. So talk to you later.